Hello, everyone. Thank you so much for joining us. I'll give folks a couple seconds to trickle in and then we'll get started. We're on a tight timeline with only 30 minutes for this briefing. Thanks so much for joining us after the holiday on a Monday afternoon, morning, wherever you may be. It's great to see so many folks coming out and joining the July monthly climate briefing. My name is Sarah Viken. I'm the Environmental Law Institute's Manager of Educational Programs. On behalf of all of us at ELI, I want to thank our speakers, Michael Gerrard, Kara Horowitz, and Ebony Griffin-Guerriere for taking time out of their busy schedules to prepare these informative updates for all of us tuning in. Typically, these climate briefings are open to our members, but in light of recent events and to celebrate Ebony's very first climate briefing with us, we decided to open up this month to the public. So we're so excited to see everyone here. We'll begin with updates from each speaker and close with a couple of minutes for discussion. If you haven't been to a briefing before, we don't have any slides. We just have brilliantly concise and informative updates from leading experts in climate law and policy. It's been a really busy month, but we'll be taking questions as time allows. So please feel free to pose any questions that you have in the chat or in Zoom's Q&A box throughout the call. There's no need to wait until the end of the program. Now, starting us off today will be Michael Gerrard, the founder and faculty director for the Sabin Center for Climate Change Law, and Andrew Sabin, professor of professional practice at Columbia Law School, with our litigation update. By the way, you can find Michael, Kara, and Ebony's full bios on the event webpage. I will link that in the chat momentarily. But with that, I will turn it over to you, Michael, to get us started.
Thanks very much, Sarah. This has been a very active month for litigation relevant to climate change. I'm going to start with the Supreme Court's decision on June 27 in Ohio versus EPA. That was a challenge to certain EPA actions under the Good Neighbor provision of the Clean Air Act, the section that says that state implementation plans must ensure that the air pollution from a state does not cause air quality violations in other states. It isn't explicitly about climate change, but much of it is aimed at coal-fired power plants, which are the second largest source of greenhouse gas emissions in the U.S. The Supreme Court took this case on its emergency docket, meaning that it did not undergo the same full briefing as a regular case. The court struck down the EPA action on the grounds that EPA had not adequately responded to one of the many comments that had been received on the draft action. This was a 5-4 decision. Justice Amy Coney Barrett wrote a rather blistering dissent, arguing that the majority was completely off base in its analysis. But the decision follows upon two prior Supreme Court decisions striking down EPA actions under the Clean Air Act that explicitly were about greenhouse gases. Its 2016 stay of the implementation of the Obama administration's Clean Power Plan, and its 2022 decision in West Virginia versus EPA, saying the Clean Power Plan was invalid because of its newly announced major questions doctrine. Also last week, the Supreme Court issued two other decisions that have great importance for administrative law. They don't directly relate to climate change, but they may be very consequential for government action on climate change. In Loper Bright Enterprises versus Raimondo, the court, as widely expected, explicitly overruled the Chevron doctrine, which involved judicial deference to the way that agencies interpret ambiguous statutes. This decision has received a great deal of commentary that our viewers have probably already seen, so I won't dwell on it, but people are free to raise questions in the chat or Q&A. In Corner Post versus Board of Governors, the Supreme Court said that parties can challenge federal regulations long past the usual statute of limitations. So I think that the combination of the Loper Bright case and the Corner Post case and the West Virginia case on major questions are going to lead to a lot of litigation challenging past as well as future EPA and other regulations. Less attention has been paid to the case of Seven County Infrastructure Coalition versus Eagle County, where the DC Circuit ruled last year that the NEPA review of a proposed rail line that would be used to transport crude oil needed to look at the air pollution that would result from the combustion of the oil carried on the rail line. The Supreme Court granted certiorari in the case. The question presented is whether NEPA, quote, requires an agency to study environmental impacts beyond the proximate effects of the action over which the agency has regulatory authority, close quote. This case gives the Supreme Court the opportunity to narrow the scope of NEPA analysis, including the effects of actions on climate change. This one is worth paying attention to. There have been some important developments in the youth cases on climate change. I've previously talked about the Nabiheen F versus Hawaii Department of Transportation case, where the young plaintiff said that the State Department of Transportation was violating the environmental rights provision of the Hawaii Constitution by having policies that encourage motor vehicles and not cleaner modes of transportation. The case had survived motions to dismiss and was about to go to trial, but on June 30th, just a few days before the trial was to start, Governor Josh Green announced that the state and the plaintiffs had settled the case. The state agreed to a zero emissions target for ground and sea and air inter-island transportation sectors by 2045. The state must set interim greenhouse gas reduction targets for 2030, 2035, and 2040, and must adopt a detailed plan for implementation and monitoring. The agreement includes commitments by the state DOT to accelerate expansion of electric vehicle charging networks, accelerate expansion of multimodal transportation choices, develop and implement policies to achieve zero emissions, and increase efforts to sequester carbon. The agreement establishes dispute resolution procedures. If a party believes that there's been a violation, it may bring a motion to the circuit court to enforce the agreement, and the court retains jurisdiction over these cases. This is the first of these youth cases to settle. In another case based on a state constitution, a New Mexico trial court denied state defendants' motion to dismiss a lawsuit alleging that the state violated the state constitution by continuing to authorize and promote oil and gas production without assuring protection of the environment. The alleged harms to the plaintiffs included impacts associated with climate change, although the court said it might ultimately decline to grant injunctive or declaratory relief based on the political question doctrine. The court found that at this stage, the plaintiffs stated claims upon which relief could be granted, including claims of violation of the state constitution's pollution control clause and claims of violations of the plaintiff's inherent rights and substantive due process rights and their rights to equal protection, their civil rights claims. So that's from New Mexico. In Montana, this Wednesday, 2 days from now, the Montana Supreme Court is going to hear argument in the appeal from the Held versus Montana decision after trial, ordering the state to take certain actions. However, the Virginia Court of Appeals affirmed the dismissal of youth plaintiffs' lawsuit against the Commonwealth of Virginia, in which the plaintiffs alleged that the defendants' permitting of fossil fuel infrastructure caused and contributed to the climate crisis and caused injuries to the plaintiffs in violations of plaintiffs' public trust doctrine rights and their substantive due process rights under the state constitution. That case was Layla H. versus Commonwealth. A state court in Colorado announced the city of Boulder and Boulder County allowed the city and county to proceed with climate change-based common law claims against 3 energy companies, but it dismissed the Canadian parent company of one of the defendants from the lawsuit. The local governments alleged that the companies concealed and misrepresented the climate change impacts of fossil fuel products while continuing to market and sell the products, leading to injuries from extreme weather, wildfires, and other climate impacts. The court rejected defendants' arguments that the claims were preempted by the Clean Air Act or interfered with the federal government's foreign affairs power, violated separation of powers and federalism principles, or violated the Commerce Clause, the Due Process Clause, or the First Amendment. So I'm out of time, so I'll stop here. Thank you.
Thanks, Mike. I'm sure there is so much more you could have gotten to just in those 8 minutes. But I'm sure we'll be watching them very closely, and we already have a few questions for you. Now I'll turn it over to Kara Horowitz, Executive Director of the Emmett Institute on Climate Change and the Environment and Director of the Frank G. Wells Environmental Law Clinic at the UCLA School of Law, with some updates out of the states. Thanks so much for joining us, Kara.
Thanks, Sarah. Thanks for having me. So I'm going to focus today on updates from my state of California and from Washington State, along with a general, more intersectional update. First, in California, environmental justice advocates and others declared victory last month in the latest battle over buffer zones for oil and gas development and production sites in the state. The oil and gas industry agreed to pull its proposed voter initiative measure from the November ballot that would have, if passed, invalidated a landmark setback law passed by the California legislature. That law, SB 1137, establishes health protection buffer zones around new oil and gas production facilities in the state, prohibiting the issuance of well permits and the construction and operation of new production facilities within 3,200 feet of homes, schools, and other sensitive receptors. But the law had been stayed from implementation because industry qualified its ballot measure challenging the law. Now that the ballot measure has been withdrawn, seemingly in part because it was polling quite badly, the setback law will go into effect. The fight is likely not over. However, industry has publicly vowed to challenge the setback law through litigation next. Also last month in California, Governor Newsom's administration proposed amendments to the landmark package of climate emissions disclosure and financial risk reporting laws enacted by the California legislature last year. As enacted, Senate Bill 253 requires the California Air Resources Board to develop and adopt new regulations by January 1st, 2025, which I note is now only about 6 months away, to implement the law, which requires large companies to report their scope 1, 2, and 3 emissions. Scope 1 and 2 emissions reporting was to begin in 2026 under the law, and scope 3 in 2027. The Newsom administration's proposal would delay all those deadlines by 2 years, giving CARB until January 1st, 2027 to adopt new regulations. Similarly, the administration proposes a 2-year delay in implementation of SB 261, the companion bill which establishes climate-related financial risk reporting requirements. Notably, the legislature has not agreed to these amendments, and negotiations are ongoing on their outcome and may continue into next month. Businesses across the country are, of course, watching carefully. And the last item from California, the California legislature just approved a climate bond ballot for November's statewide election. The Safe Drinking Water, Wildlife Prevention, Drought Preparedness, and Clean Air Bond Act of 2024 would have the state borrow $10 billion to pay for climate and environmental projects, including some that were axed from the annual budget order this year because of the state's deficit. This bond would fund about $3.8 billion for safe drinking water and groundwater projects, $1.5 billion for wildfire and forest programs, and about $1.2 billion to combat sea level rise, among other things. And at least 40% of the money would go to projects that aid disadvantaged communities. Hundreds of millions of dollars from the bond would support projects undertaken by private industry, such as proposed offshore wind farms and other clean energy projects. And it remains to be seen, of course, whether voters will support the bond measure come November, when it will compete with another large bond measure funding education. Now onto Washington State. A new Rasmussen poll shows that voters likely currently favor an initiative on November's ballot in Washington that would undo the state's climate cap and trade program. Washington Initiative 2117, the Prohibit Carbon Tax Credit Trading Initiative, would end the state's cap and trade program and repeal the 2021 Washington Climate Commitment Act, which is a state law that provides for a cap and invest program designed to reduce greenhouse gas emissions by 95% by 2050. If successful, the ballot measure would end one of the only 2 economy-wide climate cap and trade programs implemented by a US state, and the other, of course, is California. The election outcome will be closely watched by other states, including in New Jersey and Colorado. And lastly, as summer begins, a wave of climate-related weather events has again taken hold of the country and garnered significant media attention, including flooding in Florida, wildfires in California, the season's first major Gulf hurricane, and historic heat waves throughout the country. At one point in June, more than 75 million Americans were under emergency heat alerts, told to seek shelter and avoid strenuous outdoor activity. I note this because of the link between such events and state and local budgets. States and localities often bear the brunt of responding to such events, and they threaten not just communities and public health, but also public coffers. And these sorts of events really give momentum to efforts by states and localities through state courts and legislatures to try to shift some of the fiscal burden of responding to climate change onto other responsible actors, including oil and gas companies. And we'll likely continue to see such efforts grow, especially if federal programs to limit climate change and assist in climate adaptation efforts shrink. That's all I have this month. Thanks.
Thanks, Kara. It's always great to have you join us. Kara typically joins us for the first half of the year. So when we pick back up in September, we'll have Dan Farber joining from UC Berkeley. So it's been great to have you on to share all these developments, as well as Sabrina Ashton a couple of times. I know she's listening today. So thanks to both Kara and Sabrina for all of your help with these so far. Now we'll turn to Ebony Griffin-Guerriere, who will be joining us every other month with an environmental justice update. So welcome, Ebony. She is counsel at Singleton Schreiber, where she works on environmental toxic tort litigation with a focus on issues of environmental racism and injustice and the impacts of climate change on disadvantaged communities. Welcome, Ebony. We're super excited to have you join us, and I'll turn it over to you.
Hi, everybody. Thank you so much for having me. I'm very excited to be here. I am mildly nervous, so I will probably either talk really, really, really fast and you won't be able to understand anything that I'm saying, or I'm going to drag it out. I'm going to try to meet it somewhere in the middle, so I don't keep you here all day. So today I wanted to talk a bit about the Department of Justice's Environmental Justice Strategic Plan. But before I do that, I wanted to provide a brief overview of why public input into the plan is so critical right now. And I'm going to do that by highlighting a series of news stories that are coming out of Cancer Alley in Louisiana right now. And there's been a lot happening in Louisiana, specifically in Cancer Alley, since the EPA closed its Title VI investigation against the state. For those who are not aware, Cancer Alley is an 85-mile stretch of land. It sits between Baton Rouge and New Orleans, and it's home to about 200 petrochemical facilities and refineries. So in 2022, Earth Justice filed a Title VI complaint with EPA on behalf of residents of St. John the Baptist Parish in Louisiana's Cancer Alley. The complaint alleged that residents face the highest risk of cancer in the country due to carcinogenic emissions from petrochemical manufacturing facilities in the area. The EPA at that time agreed to investigate the complaint, but then it dropped its investigation after the state sued. And so in January of 2024, so earlier this year, a federal judge actually blocked the EPA and the Department of Justice from enforcing disparate impact requirements against the under Title VI. Excuse me. So pretty much for decades, residents living in Cancer Alley have been pressing the federal government to intervene, but especially following the EPA's decision to close the investigation. And this includes them asking EPA to mandate that all Clean Air Act regulated petrochem and manufacturing facilities have fence line air monitors, limit excessive flaring events, install leak detection systems, and close loopholes that allow for increased emissions during extreme weather events. EPA is also currently under pressure from about 23 state attorneys general to stop taking race into account when regulating pollution. And on the state level, the Louisiana governor recently signed into law a bill that would prohibit environmental officials from using any community-led air monitoring data in any enforcement actions or regulatory actions at all. And so last Monday, the Monday before last, June 24th, a group of local activists attended the DOJ's public meeting regarding the Environmental Justice Strategic Plan. And they've urged the agency to take whatever legal steps it can to block further expansion of petrochemical facilities in the community, which have been disproportionately impacted by pollution. And I wanted to highlight Cancer Alley because it is a classic case of residents doing everything that they're taught to do and they're told to do, by everyone basically to try to stop expansion of these facilities into their backyards. And it just hasn't worked. And so it's really important for, the public to be aware of these issues and be educated on these issues. So when opportunities like the Department of Justice Environmental Justice Strategic Plan come available for public comment, we are, able to do that and ask them to do the right thing. And so I wanted to talk about this today because DOJ recently extended the public comment deadline. It's now July the 22nd, so you all have time to make comments. And essentially, I'm going to do a quick summary of the plan. So under Executive Order 14096, revitalizing our nation's commitment to environmental justice for all, it requires that DOJ publish an environmental justice strategic plan outlining its vision, its goals, its priority actions, and whatever metrics it plans to use to address and advance environmental justice. And this plan must be posted by October of this year. And so the Department of Justice, they define environmental justice as the just treatment and meaningful involvement of all people. They've identified 4 draft goals. So goal 1 is to prioritize cases and make strategic use of the department's legal tools. And then under that is the strategies they plan to use, which are prioritize cases that will reduce public health and environmental harms, and also pursue the full range of remedies that are available under the law. Goal 2 is to meaningfully engage with impacted communities and expand efforts to communicate environmental justice efforts. They plan to track DOJ's progress through increased reporting and also increase community outreach, public participation, and increase awareness of the Department of Justice and its environmental justice initiatives. Goal 3 is to increase education and collaboration within and outside of the Department of Justice. And they plan to continue development of environmental justice related training for DOJ staff, expand efforts to collaborate with federal, state, local, tribal, and territorial partners. And then goal 4 is to assess and evaluate environmental justice in DOJ's climate adaptation efforts, including management of its procurement and real property. Also ensuring DOJ considers environmental justice in the management and operation of the agency. And so the agency has invited the public to answer 5 questions in its public comments to kind of help them figure out if, these are the right goals that they should move forward with. And those questions are: 1, what additional goals and objectives should DOJ consider in its plan? 2, how can DOJ improve its outreach and engagement efforts with communities about environmental justice? 3, what information and resources should the Department of Justice provide to communities to clarify its environmental justice efforts? 4, what topics and considerations should the Department of Justice include for staff training on environmental justice? And 5, what organizations in your area should DOJ add to its environmental justice listserv? And so I want to encourage all of you who are engaged in this space and who are engaged with community groups in this space that are fighting for environmental justice to just make sure that they are aware that the strategic plan is out there. If you have clients or partners who are, advocates for environmental justice and just treatment under the law, there is information on DOJ's website. I'm also happy to provide it here. Like I said, the public comment period is open until July the 22nd. That was recently extended. And yeah, I just want to, encourage people to take some action and make sure that everyone in your circles are aware that there's this opportunity to provide some real meaningful input that might actually help communities.
Thanks so much, Ebony. We're super excited to have you on, and we do have a couple questions before we jump into more general discussion about the justification being given for not allowing citizen monitoring data, if that has something to do with federal reference or federal equivalent methods or something else.
Sorry, I was trying to find my mute button. The rationale that I can find is basically that they just want to make sure that everything is consistent and that there's no challenges to the quality or the quantity of data in court. And so by using the same processing facilities and the same methodologies, I assume that they're seeking to minimize those impacts.
Awesome. Thanks so much. Now we'll turn it over. We have about 5 minutes for discussion. So before we get to audience questions, I want to open it up to any of our speakers. If you have anything else to add or any comments on the topics you've all raised today, I'll open up the floor to all of you.
Well, I'll just mention there was one other case that I didn't get to mention, but it actually is in line with what Ebony was talking about, which is that a federal court in Louisiana granted a motion by the state of Louisiana for a stay of the Biden administration's moratorium on new approvals of liquefied natural gas export facilities to non-free trade agreement countries. The court found the action was reviewable final agency action, and it concluded that the moratorium by the Biden administration was arbitrary and capricious, violated the Congressional Review Act, and all kinds of other things. So this was another lawsuit which goes counter to environmental interests, in line with some of the other ones we've been hearing about at the federal level.
I have a question for you, Mike, if you don't mind. And actually, I'm stealing it. It was my question, and now I see it's also Scott Hudson's question from the open Q&A. And it's about the relationship between the corner post decision on APA statute of limitations and Loper-Bright, and whether, given Loper-Bright's language that past decisions are not unsettled by the change in law on Chevron deference, whether we should take some comfort that, in fact, the combination of Loper-Bright and corner post isn't reopening a whole swath of decisions for relitigation without Chevron to protect administrative decision making, or maybe we shouldn't take so much comfort from that. I'm curious what you think.
So in the first place, the language would only seem to affect regulations that have already been litigated and upheld based on Chevron. So there are a lot of regulations that have not previously been litigated or were not upheld based on Chevron. But notwithstanding that language, we're already seeing the lawsuits come. We're already seeing a number of lawsuits brought using the corner post sort of extension of the statute of limitations, or its interpretation of the statute of limitations, and saying that the agency was wrong whether or not Chevron was granted. So we're already seeing the beginning of what I think will be a wave of litigation challenging regulations. And let me also say that it wasn't surprising that the Chevron doctrine was overturned, and I think that has for some time already been having a deterrent effect on agencies from going as far as they might otherwise go. And the prime example of that is the SEC's regulations on climate disclosure. The draft regulations called for disclosure of type 3 emissions, the final didn't. And I have to think that one of the reasons may have been that the SEC thought that that was likely to be overturned through some combination of lack of Chevron deference and the use of the major questions doctrine from the West Virginia case.
Thanks.
We did have a couple more questions about Chevron, but we had also had a question about how an administration change could reverse or even ignore different EJ regulations, maybe some of those that Ebony, you were discussing. So I didn't know if you had any thoughts on that as we're looking even ahead to the fall.
I will keep it brief and just say yes, that generally speaking, a new administration could reverse a lot of these sort of last minute decisions that, are trying to be made. But there are a lot of efforts right now that are being made in Congress to codify particularly disparate impact regulations into certain bills. There's the the Donald A. McEachin Environmental Justice for All Act that's circulating that could really help sort of mitigate quite a few of these issues. But then, of course, again, with the administration change, potential administration change, everything would just kind of be up in the air. So,
yeah, and there is, of course, an important line of Supreme Court cases saying that if an agency is going to reverse a prior position, it has to come up with a detailed explanation for why it's doing that. But I assume that if there's another Trump administration, they'll come up with explanations for that, and a friendly judiciary might uphold that.
Yeah, so all right, I'm taking a quick look and see if there's anything we didn't address in the Q&A, but I think we've actually hit on most people's, unless anyone has anything else to say about Chevron, any further thoughts about any of these suites of recent SCOTUS decisions.
Just that they continue an effort that's been going on for some time by this Supreme Court to weaken the administrative state. And I think that's the agenda that some of the justices have, and they're making a lot of progress in pursuing that agenda.
Right, and with that, we've hit our half an hour, 5:30 mark. So thanks so much for tuning in to the July briefing, everyone, and for everyone's engagement and questions. Thanks to Kara, Michael, and Ebony, of course, for joining us every single month. And this briefing will be recorded. It'll be posted on our website on that event webpage that I sent in the chat earlier, or you can just find it on our website. We'll be pausing next month in August. We do this every year, but we'll pick back up in September. So stay tuned for more information on our fall schedule. And to make sure you never miss a briefing and gain access to ELI's leading publications, programming, networking, and more, you can also consider joining ELI's community as a member. We'll have more information available on our website about membership. Thanks, and we hope to see all of you again in the fall. Bye, everyone.